Judge Gordy, you want to?
Sure, I'll move down one.
Oh, here.
Okay.
And
So you're going down to the other end. So Patricia is going to be moderating this next panel, and we are extremely lucky to have three distinguished judges up here on this panel. Judge Rosenbaum is a judge of the Supreme Court of New York. He has been responsible for, until very recently, for managing, handling, settling all aspects of the lead docket in his jurisdiction in New York. He has settled probably hundreds of these cases, knows all the players, knows the law, and knows how to settle a case. We have with us from Baltimore Judges Gordy and Smith. All of us in this room, most of us, have had the pleasure of appearing before each of these judges on numerous occasions. They have between them decades and decades of experience on the bench. They've both tried lead cases. They both have acted as settlement judges. They know the law inside and out, and I can't imagine a better three judges to have on this panel to talk about mediation, settlement of lead cases. And with that, I'm going to let Patricia get started.
Thanks, Brian. I'm going to stand, and we'll let the judges sit. Imagine that. We'll do it this way. I just have to add to what Brian said. I had not had the pleasure of meeting Judge Gordy or Judge Smith before today, and truly, you talk about for all three of these judges, just judges that are truly committed to us as attorneys, just to helping us and to, committed to the profession, and they're here to answer your questions. I can't stress that enough. And Judge Rosenbaum, though his bio says recently completed his term as the designated lead paint judge, I put completed in quotes since yesterday he was mediating some cases for myself and a plaintiff's attorney that is here. So when you talk about being tireless, tireless commitment to this, he has shown that time and time again. We have some questions. I put together some questions, and we'll get started with these questions geared toward the judges. Again, if you have your questions, you could save them for this portion, or you'll see these judges again for the judicial roundtable and can ask the questions at that time. So we will start with Judge Smith. Certainly, Judge Smith, there are differences between pretrial conferences and mediation sessions. In your opinion, having obviously sat on the bench and now working more with ADR, how should an attorney address those differences to achieve the best outcome for their client?
A couple things. I think the obvious difference is one that has to do with the amount of time available. When we talk about pretrial conferences, to me that means the court required at the courthouse conference 30 days before trial, as we do in Baltimore City. Some jurisdictions in Maryland do it a little bit differently, different times, but it's still the court-sanctioned or provided conference. Judge Gordy and I both still do those conferences on a regular basis for the courts, and on those days we know we're going to have a docket of cases that are scheduled every half an hour. So the likelihood of having enough time to be able to deal with the lead paint type case is somewhat difficult. I think you have to deal with the differences in the sense of how much likely preparation am I going to have had for a pretrial conference when I show up that day. I haven't been given any information in advance. If I am a lucky person, there will actually be court files there. Often I am not a lucky person, and the first part of my morning I spend time trying to find someone in the clerk's office who may know somehow where a file is. In terms of, I guess, another difference is how you format the information available to me. With the pretrial conference, I really almost need, at best, bullet points, the highlights. If I'm doing a private mediation, obviously I receive, thank you, and expect to receive a lot more information in advance in terms of, again, I want the highlights. I don't necessarily need every record and every report that's been prepared, but it is not uncommon to receive the neuropsychologist reports and such, or at the very least, the highlights from the neuropsychologist reports and such. And I think the difference, too, is in terms of how you prepare your client for the pretrial conference versus mediation. Mediation, as I see it, involves it's a process. It is a dance. It has to happen, and it involves a lot more of creating a relationship, developing a relationship, and then working through and convincing the parties, or at least raising issues that help the parties continue to reevaluate the strengths and the weaknesses of their cases.
Thank you, Judge Smith. Before we go on, we had prepared fact scenarios that are in the materials. Actually, I use the word we kind of loosely. A very talented and determined law clerk in our office prepared very detailed fact scenarios, and since we've gone green here, you may or may not have had an opportunity to look at them. So I will cut to the chase. They are, as you could probably imagine, the scenarios that we see in, if you haven't had a chance to look at them, most of the lead paint cases. Some you have, classic landlords that are sometimes referred to as slumlords, and some you have more ideal plaintiffs, and some you have plaintiffs that present with lots of confounding factors. So that's basically, if you haven't had a chance to look at the scenarios, that's what they are. They're two separate scenarios, one personally more pro-plaintiff, the other one more, slated toward the defense. And with that said, Judge Rosenbaum could decide whether he wants to particularly point to those or not. But the question for Judge Rosenbaum is, certainly, Judge, as you well know, as we all know, every case has its strengths and its weaknesses, and we saw that in the scenarios presented. What do you consider, or what would you like a plaintiff's attorney to play up as the greatest strengths of their case, and what do you consider the greatest strengths in a defendant's case, or what's most important to you if you're trying to work on a settlement?
Thank you. Several things. First of all, I do want to thank HB Litigation Services. This is my third year in a row of being able to present here, and I'm very flattered and appreciate. I want to thank Mark Richter and Tom Cullen for the last couple of years. They asked me to present, and now Brian and Patricia. I appreciate it very much. This is really one of my favorite bars. It's a great collegial group of individuals. I say that because not only is it true, but for those of you who don't have a great deal of experience in the lead paint litigation field, haven't tried a case, relatively new, I would recommend that you just walk up to somebody who you've heard speak today, or to someone else you know in the field that has a lot of experience, because this is not a cliquey group. This is a very open group, and I really appreciate it, and that means a lot to me as a judge. Judges are students of human nature. So when you ask me that question, Patricia, I'm thinking about not only human frailty, but the basis and background of what's going on here. I do actually like to get the full set of materials from the doctors to the settlement offers that are for settlement purposes only, and review them thoroughly. I also don't mind getting cliff notes on those as well. So if you have highlights you wish to just point out to me, I'll know what you think truly are the strengths of your case. And that helps move the process along. So as Patricia knows, and the other attorney who I was involved with yesterday, Neil McKinnon, they both asked me last week if I was interested in mediating cases, even though as the supervising judge of civil courts, I'd handed over this docket to Justice Ark, who's handling them very well right now. I went to Justice Ark, and he agreed to turn over those 10 cases. We settled 4 of them yesterday. We're hoping to do the other 6 today. But what we got, what I got, and what they know I look for, is I first asked the plaintiff's attorney, what were the lead levels? How old was the individual? What was hers or his upbringing like? What was their education like? How did they do going through school? What are they doing now? I asked the defendant, what are the confounding factors? What was the prenatal care? What was the home life like? Is the child with one or both parents? Are they with a grandparent? All these things sound very familiar to each and every one of you, I know, because you've seen these time and again. There's no real magic, but I look at those to see how I can evaluate a case in terms of where the dollars are going to be. When you come in to settle a case with me, you know, or with any judge, you know that this is a settlement conference. It's not an opportunity for you to say, this is a no-pay case, or for you to say, I'm going to ask for that pie in the sky we saw earlier today. You both know that if you truly wish to settle this case, you're going to come in and you're both going to have to compromise at some point in time to get to a settlement. So that's just an outline of what I look for, Patricia, when I'm beginning that whole process.
Thank you, Judge Rosenbaum. Judge Gordy, again, you can decide whether or not you want to refer specifically to the scenarios. Again, I don't know that it much matters, but as you know, in some cases, there are more confounding factors present than there may be in another case. Having tried lead paint cases and also having mediated them, how much weight do you believe that jurors place on those confounding factors, and how much do you place on them when you're mediating a case?
First of all, thank you for the invitation. Picked a great city to have this seminar or conference. And I think I should say that 6 years ago, after 21 years as a judge, I retired. And I must say that I like being a judge, but I love being a mediator. And I'll tell you the secret. The secret is I don't have to decide. And that's a wonderful position to be in, believe me. The question about confounding facts. Well, confounding facts is what brings everybody here. In the scenario that we were given, there were all those confounding facts that you deal with. One plaintiff has high lead levels in one house and low lead levels in a later house. There's another plaintiff in another scenario who has even higher lead levels in the first one, but he is doing well and in college and getting a job, and so the question is, how do I handle those confounding factors? Well, in every mediation that I get involved in, when I receive the materials, I do a chart, and it's an easy chart. It has pluses on one side, minuses on the other. I compare it similar to the guidelines we get in Maryland in death penalty cases on the criminal side. The jury is to weigh the aggravating factors against the mitigating factors. If the aggravating factors outweigh the mitigating factors, lead paint is certainly not a death penalty case, but I consider certain pluses as aggregating factors, and I look at the defense side and see, well, are there any mitigating factors that will bring this demand or this situation down? Of course, we all know that aggravating factors are such things as high lead levels, long period of time of exposure. Mitigating factors may be such things as the landlord is really a decent guy who's doing his best, and et cetera, et cetera. So that's how I deal with the confounding factors. The quick question was, how do you address these factors in mediation? Well, mediation is a whole different animal from trial and from settlement conferences. Judge Smith has pointed out the differences. In a mediation, you have literally all day, or as long as you may need, to engage the parties in what I call reality check. Reality check involves a whole lot more than the confounding facts. Every case, in my opinion, is resolved or not resolved based on reality check. Reality check involves such things as the jurisdiction, the competency of the counsels, the presentation of the parties, and et cetera. Cases resolve or do not resolve primarily for matters that have nothing to do with the facts and the law. I know that comes as a shock to you. But behind the scenes are always these other matters and issues involved. As complex as the insurance adjuster can't stand the plaintiff's attorney because he beat him out of a case 5 years ago. Or something so complex as mama who's there representing the adult child can't decide because she hasn't checked with her fiance yet. and everything in between. So the confounding factors in a mediation are always considered, but there's always much more, and mediation is a process that takes time to get to those issues beyond the facts and the law. I think the last part of the question is, to what extent would evidentiary concerns be considered during a mediation? Well, in a mediation, evidentiary concerns are always important, as they are in a trial. In a trial, it is a search for the truth, at least by one party. In a mediation, that is really not the objective. The objective is to protect the parties from excesses.
Judge Smith, you have something to add?
Yeah, just, there was I think part of your question intrigued me, and it was that, how much weight do we place on the factors, and how much do we find that jurors place on the factors? After, in a busy urban jurisdiction, generally I would say we didn't have time ever to interview jurors and find out, how they were influenced. You have more opportunity to do that, certainly, than we ever have. I honestly, and I don't know how much those factors influence jurors. I think that part of my responsibility in mediation and in the settlement conference, as time allows, is to point out, here is a factor that may have an influence on someone who hears this case. Part of my job is to point out that, to each side, you have to hope that, at least in Maryland, 6 strangers, whom you do not know, your clients do not know, are going to perceive everything perfectly from your point of view. Because this search for truth, as I'm fond of saying, if you want absolute truth, I have a sister who's a theologian, you should have hired her. What we're dealing with in the courtroom, and what we're dealing with even in the context of mediation, is perceptions of truth and perceptions of the strength of evidence and such. So I think that part of what, and I also, I've mentioned to several lawyers here over the course of time that I think every trial lawyer should have the opportunity to sit in a jury, and I know lots of us don't get that chance to do. I've had the pleasure of being on a civil jury. Most interesting experience of my legal life, because the instruction that the judge gives about, and you must decide this case only on the evidence presented in this courtroom and the law that applies to it. And now you have to add in, don't look on Facebook or Google anything. The reality is, when those folks get in the jury room, they talk about whatever they want to talk about, and it's very hard in Maryland to impeach a verdict, as I'm sure you know. The one time that I sat on a civil jury, I spent my time saying the following: well, that's really interesting, but do you remember the judge told us we had to decide this case based on the evidence that was presented? There wasn't any evidence about that point. And if you've ever been to Baltimore, you know that there's a certain really lovely accent. And so the jurors said things like, well, I know what you're talking about. Here's what I think Roy happened. I think this is what Roy happened. And I said, well, you might be correct about that, but there's no evidence. I know, but everybody in this room knows that's the way things go in that neighborhood. Okay, fine. In any event, now, Thank you.
Never follow dogs, cats, children, or a comedian.
Well, there's some people who do, stand-up comedy. I've always done sitting comedy, but in any event, my point is that we don't know how those, and even when you do the interviewing afterwards, I think a jury is, I guess it's a living creature in itself, and the dynamic in each and every jury, I think, is a little bit different. And you may get some, good information and ideas, but you don't know how they're going to use the information. And really, I think our job, as I said, is to at least point out, Judge Gordy and I have, talked about these things many, many times, not to say, well, here's what's going to happen, this is, if you go to trial with this case, this is what's going to happen. He and I don't know that. But what we're likely to say is, here are the things that I think you have to be concerned about, as I'm also fond of pointing out. It does me no good to point out to whoever I'm talking to, the strengths of their position when you're doing a mediation. I guess I should probably be nice and do that, but really, it doesn't do any good. It doesn't really accomplish much of anything. The point is, what you have to worry about always is, what are the weaknesses on my side? What are the strengths on the other side? How might those, play out inside of a courtroom? Thank you.
Thank you, Judge. And the next question is really for all the judges. Have any of you ever had a situation where you did not approve of an infant settlement? And in that context, I guess following that, have you ever had a case where you were concerned about the competency of the parent to approve the infant settlement, or if there was an adult plaintiff? And what are your suggestions or experience to the extent that you can share it with us? Judge Rosenbaum?
The latter part is what did in fact happen. I've had several parents who really did not pass muster in terms of their ability to understand what the settlement was about, and in one case tried to relitigate the matter against me personally because they felt that I was keeping money from them, which was what the money was for, not their child. Situations like that, I sit down with the attorney with both attorneys, by the way, just to instruct the attorney what's been happening so she or he has kept abreast, and have told them that this is a case that will likely continue to be a problem, and in fact, they should consider having me appoint a trustee for the child. And that's basically what has happened.
Thank you, Judge.
I think you have a lot more control as a judge in that situation. Not that you don't have any, as a mediator. But as a judge in a courtroom, when the case comes in for a settlement conference, I think you have a lot more, or there's a verdict, you have a lot more control of that situation. As a mediator, that's a little bit more of a dance.
Yeah. With respect to the aspect of the question that talks about approving infant settlements, my experience in Baltimore is that I don't think anybody, when I was on the bench, ever asked me to approve, at least what I would understand you mean by an infant settlement. And I don't think that's really kind of a standard, maybe it is and nobody told me, but I don't think it's kind of a standard practice in the jurisdiction that I'm familiar with, and perhaps that's, and I know as far as our bench was concerned, at least those years when I was still actively serving, you know, the point of view, our perspective was that the parent as a natural guardian has a legal right to settle a case, you know, on behalf of a child. And with the infants, and I've been requested in other contexts when I was on the bench, medical malpractice cases and such, where there was a you know, kind of a catastrophic injury to a child, you know, birth-related injury, to approve those settlements. And you almost have to have a mini trial to get sufficient information to be able to do that. But maybe the lawyers could comment from Maryland, but that's not, is that typical?
In Maryland, it's a little different than most other states. In Maryland, there is no court approval required for a minor settlement. What is required is that if the child is a minor, the funds are placed in what's called a Title 13 trust. We have, as plaintiff's lawyers, there's a specific way the check must be made payable under the statute, and its Title 13 is specifically referenced in the payee line. The bank then opens the account as a Title 13 trust, and any distribution that is made from the trust must be made after application by the guardian, after approval by the court. So it doesn't have, the settlement doesn't need to be approved, but how the money is spent during the minority does.
The question here is, are you ever concerned in the context of the infant settlement of the competence of either the parent or now adult plaintiff? I think the truthful answer to that is we have concerns in most cases, but those concerns are not always addressable. Sometimes you have to trust the right thing will be done, and that usually leads to a discussion about structured settlements.
Thank you, Judge. Judge Rosenbaum, we'll direct the next question to you. In the scenarios, you have situations which, again, we see all the time, and Mark Richter touched on this in his presentation. You have a case where you have two siblings, and perhaps you have one we'll call them two sisters. You have two sisters. One has much higher blood lead levels, but seems to have achieved a certain level of success, maybe 21, has an associate's degree, maybe moving on to college, but had extremely high lead levels. And then you have a sibling in the same action, and that sibling perhaps had significantly lower lead levels, but has not really achieved the same level of success, perhaps a significantly lower IQ. as you're dealing with either helping us settle the case or in an infant settlement, how do you deal with that, and what are your recommendations for how an attorney should address that to avoid any potential conflict?
It's a very good question. And as you know, we had a case similar to that yesterday that we did settle. So there's a couple ways. First of all, I operate understanding, coming from private practice, these are your cases. Maybe my courtroom, but it's your case. And in my chambers, I ask how you would feel most comfortable handling the case. And I ask both sides, together and separately. And that's when I play them off against each other. And ultimately, we are able to get a settlement that way. But what I will typically do is separate those two out. I don't think you can really mash them together. Probably one policy, maybe there's two policies for two kids. But especially if there's one policy, I still feel it's important to separate them out and feel out the plaintiff, first of all, as to where she or he is coming from, and understanding making them look ahead. I bring up my religious term, WWJD. What would jurors do? And if you knew that I was an observant Jew, that would even be more funny for you. But in any event, I always remind them that when we're settling a case, remember, if the case doesn't settle, we're going to trial. And more often than not, quite often, it's going to be a jury trial. So then I have them think about their clients, their witnesses, and what, in fact, how that's going to play with the jury when I've got two plaintiffs, and one has a higher lead level but excelled in school, and one with a lower lead level who had real problems and real struggles. In the 7th Judicial District, which covers 8 counties, about 1.5 million people, which is my district, we have only tried to one trial to one conclusion, a jury trial. That is our benchmark. We have had hundreds and hundreds and hundreds and hundreds of settlements, but only one case that went to verdict on a jury case. We've never even had a bench verdict in the 7th JD because we settle so many cases. So we're limited into where we're at and in terms of what precedent we have for juries. So I have to work with both sides in seeing how we can compromise on both of those issues. It's very tricky, but I have to, the key thing for me is I hold the jury component over their heads, and that helps, I feel, in getting them to begin to realize that how they're going to be able to settle their case. That's my key component.
Thank you, Judge. Judge Smith, we'll direct the next question to you. Often as attorneys, I think everyone in the room will probably agree with me, we often say, come on, we could write each other's expert reports after a while. And in the scenarios that we had, in the second scenario, we see that the defendant, as is typical at least in upstate New York where I practice, the defendant retained a neurologist and a neuropsychologist. The plaintiff in that scenario retained a neuropsychologist, a pediatric expert, and an economist as well. How much weight do you afford in a mediation session to each expert's report, and how do you deal with conflicting information, specifically where there's a significant difference in measured IQ by each expert?
Of course, I'm always shocked that there are such differences when you have 2 PhD neuropsychologists preparing reports. How could that possibly happen? I struggle to understand that. But in any event, I expect that there are going to be some differences. What is interesting to me is the occasion where the defense neuropsychologist actually finds, take full-scale IQ, for example, to be lower than that of the plaintiff. And I can think of a recent case in which that was a surprise to me, that I hadn't seen that for a while. I would say that, frequently there really aren't huge differences. I mean, there may be, but I expect that there are going to be differences. I think everybody expects there to be differences. Again, how much, weight do I give to that? It's among the factors that, depending upon who I'm talking to, how I'm going to use the information. I don't mean to suggest that I have no intellectual integrity at all. I really do. But in this process, you know, sometimes you're using the same information, but you're managing it for slightly different purposes. In terms of what do I like to get in advance, if I'm doing a private mediation, I expect that I'm going to receive, often I receive the full reports, as Judge Rosenbaum mentioned. Sometimes I get simply the highlights from those reports, and it really depends upon the particular case as to what the lawyers feel I think is going to be the more persuasive to me than what I want. If you send me something, I'm going to read it. I'll just put it that way.
Thank you, Judge. I'm sure we all appreciate that very much. Judge Gordy, I'll direct the next question to you to start, but then I would ask that Judge Rosenbaum, just so we get a New York perspective, weigh in as well. In the scenarios, and again, you can imagine, if you didn't have a chance to read them, you can imagine what they say, but we have one of the plaintiffs that was arrested, and then in another, you know, basically has not accomplished much. I'll try not to be too defense aggressive in the vocabulary that I choose, but he was arrested, has accomplished very little. And then in a second scenario, to present a balance here, the plaintiff who was exposed to lead as a young child is now a young dad. He learns a trade. He's seemingly taking responsibility toward being gainfully employed. And then to be fair, in the scenarios, in one scenario, we have a landlord who gets notice from the Department of Health, abates immediately, does everything he was supposed to do and more. And then in the second scenario, we see the landlord that apparently thinks he could ignore these notices until many months go by. So what is your advice, starting with Judge Gordy, and again, don't refer to those particular facts, but what is your advice to us, either in the courtroom or in the context of a mediation, when we have really undesirable clients, beyond just the confounders that are present in cases, but the ones that, you know, you wish you were sitting somewhere else?
I think I'm going to start by telling you a true story, a short true story. And I won't call any names of who a lawyer who was involved. But it was a mediation in a lead paint case, and the defense pulled out a picture from Facebook of the now young adult plaintiff, male, in the typical gangster pose, in a halo of smoke, and holding a blunt in his fingers. Looking very high up. The defense couldn't wait to threaten to put this into evidence, and that it diminished the plaintiff's case to a great degree. When I took the photograph to the plaintiff's lawyer, he had a great response, but that was only going to lead up to the comeback of the year. His response was, "Judge, this shows that my client has congenitive and cognitive defects as a result of lead paint, and his judgment is just not good." Now, before I became a judge and sat in criminal court, I thought a blunt was a pencil that had a broken end. I soon learned differently. But anyway, I thought, well, that's a response. The lead paint led to this. When I went back to the defense and showed me this picture and explained to them that this was only an example of the cognitive deficiencies caused by lead paint, their response was, well, that may be true, but we think that when the jury gets to the damages part, if they get there, that when they get to the damages part of the case, they're not likely to want to see their award fall into the hands of bling and frolic and the hands of some pharmaceutical street farmer in Peru, which I thought was a good comeback, because no matter how liberal jurors may be, none of them in any jurisdiction, liberal or not, want to think that their award will be flittered away on silliness. And that was an important part of the mediation. But I think Tom Cullen was very accurate this morning. He says if you have something like that, you have to be very careful how you use it, because it can come back to bite you. In this mediation, it didn't bite anybody, but it was a factor. So in every case, whether it be in the courtroom, whether it be at settlement conference, whether it be in mediation, there are these pluses and minuses. And this is just a part of the discussion. You know, the landlord on one case may be the landlord who is going to heaven with a halo because goodness knows he's tried. Another landlord may be on his way to hell in a handbasket, pulled by a supersonic jet with flames coming out of it. And these are the pluses and minuses that we need to discuss. The best thing about any discussion about settlement is candor. And sometimes that is the most difficult part for the mediator, is to get the folks to confess. Because as I said, the job of the mediator is to protect you sometimes from yourself and the excesses that you may be exposed to.
Thank you, Judge Gordy.
I think that Judge Gordy just did a fantastic job of describing how you handle cases such as that, and I hope I handle it that way when I'm settling cases. You know, you have to come to a point where you're realizing what is real about your case and understanding. And again, I have to say a benefit for all of us in this room is the collegial atmosphere that's here. Everybody knows everybody. And as a result, understand that honesty really is going to be the best policy before the judge, before the mediator, and you can have a host of situations break down at trial. Our trial that we had, the Ashley Hicks trial, I found fascinating because the defendant was a retired fireman from the city of Rochester and was well respected and also owned an establishment, a grocery, and was well respected and well liked. And by the plaintiff's own admission, came in on a regular basis to check on the family and see how they were doing. That all being said, the negligent abatement of that property was horrible and caused a major issue that the jury sat there and looked at what was going to be the factor in deciding this case. And I was stunned because I thought when Ashley Hicks got on the stand and talked about how much she liked this guy and talked about him being a fireman, the jury, they were sitting there, they were leaning forward, all the indicators, and afterwards, one of my favorite things about being a judge is jurors will actually tell you everything as opposed to when you're practicing. And they just could not get over the fact that he had not taken care of this property. He may have gone and visited the plaintiff and her mom, checked on them, walked around the premises, but did not do his job. So when you've got a case where you've got a landlord such as that, or you have a plaintiff such as the one that Judge Gordy mentioned, and then you've got another one who, by the way, as Patricia said, you've got a young, hardworking father. He's dedicated to the family. The father's in the picture. He's the plaintiff. He's learned a trade. You also have to balance that out as well. How is a jury going to respond to that? So it does hit on both sides. And it really is, the honesty is the best policy, is the best method. This is your opportunity to be candid before the judge, separated, so you can really give him the full picture, and so you can have a full and open and honest discourse, knowing that that judge is going to keep what you have to say to himself and not share it with the other side, so the other side can feel the same way, and then hopefully come to a settlement.
Thank you, Judge Rosenbaum. I think I have to add, because you'll hear from Ann Joint later. She's in the back. She's probably giggling because I myself was guilty about 2 weeks ago of sending her, thank goodness it was just in the early stages, it was in the context of an email as opposed to doing it in front of the judges, an email following a Google search with a plaintiff that had, I think, an unusual name. And so I send her an email that says, hey, I know we're both really jammed. Looks like your client was just arrested for possession of crack cocaine and is, being arraigned. How about we put these off now? And she, there was a bit of a pause and then responds back, not my guy, smiley face, we're ready to go forward. So I was like, okay, well, good thing I was wrong in that context, and not, embarrassing myself for not having the full information in front of the court, or God forbid, in front of the jury. I'll direct this to all the judges. Certainly each case is unique and there's no hard and fast rule, but we often see, and again was presented in the scenarios, sometimes we come to you either as a pretrial conference or in the context of a mediation with no expert disclosure. We don't have a trial date. We don't want expert disclosure quite yet. We have all discussed, we know how expensive it is to litigate these cases, and maybe we come to you at that point in the game. If the parties are serious about settling the case, in your collective experience, what is the best time for a settlement conference or a mediation session to take place? Do you want to start, Judge Smith?
Oh, sure. I think it seems to me that you have to have at a minimum some basic core, what I would think of as sort of core discovery. And I would say that the really early settlement, is not the tradition and culture where I come from, except in the one context in which I think it is possible to do. There are often cases which involve multiple family members, siblings, cousins, folks who multiple related, subgroups of families that have lived together, and you may have gathered information, substantial information about one or more of the. You know about the lengths of tenancies, the durations. You probably have information about lead levels that might correspond to the particular periods of time in a particular property and such from an earlier case, and that gives you the opportunity to have some assurance. I mean, I would be, if I were you, I would be concerned about my own professional responsibility if I didn't have sufficient information walking into it. Mr. Wilson mentioned something about, is the insurer willing to buy the risk? Well, I would think, knowing what I know about insurers, they like to have some specific information that has some level of detail to it. So I think one reason why we do the pretrial conferences in Baltimore City 30 days before trial is to assure that there has been, and we know that you have complied with the pretrial orders and that all of your discovery has been completed way in advance of the pretrial conference, right, Gus? And he just smiled as I was saying that, so it was just an easy shot. That's much easier. But I think the really super early, it's difficult because, it could come back to bite everybody because you don't have enough information to make a realistic assessment about the valuation of the case.
I think the question has in it the answer. It says, if the parties are serious about settling the case. When the parties are serious about settling the case and can see why that's a good time to have a settlement or mediation.
In New York, for those of you who don't practice in New York, we have our own IAS system, which means that we take our cases in every type of case from cradle to grave. So we have it at the beginning, we assign the discovery schedule, we hear the motion practice, we offer to conference the cases, and we try the cases. My understanding is that's not the method in Maryland. So, obviously each side has its positives and its negatives. I happen to like that system, and what I'll do is I'll conference the case early on, and I will set up the scheduling order, and we'll get our discovery done, and at the end of the discovery, I'll offer to do a pretrial conference. At that point in time, we'll see where everybody's at. However, that being said, there are those absolutely unbelievably high lead level cases, and you don't have a strong case as the defendant where the defense attorney is going to come to you and they don't have a really high policy. Those types of cases, they might be motivated, in which case they'll ask me to give a call to the plaintiff, and I'll call the plaintiff and bring them in. By the same token, I'll get the plaintiff attorney who calls me up and says that he's got this case, but his client's in jail for another 10 years for armed robbery, and they kind of would like to take care of this, and they figure they can work it out at a severe discount or something like that, in which case I'll settle those cases. But those are the extreme ones. Otherwise, it really is at your pleasure. It's your case. So you'll contact the court. But in New York, I'll contact you as soon as we get that request for judicial intervention, and we'll set up a conference and then set up a discovery schedule.
Thank you, Judge. This next question is directed to all three of the judges. For a successful mediation or a successful settlement conference, We certainly all know it. It's important to have the correct and the appropriate decision maker in the room or at least on the phone. Do you require the parent to be present at a settlement conference? And by that I mean even if you have an adult plaintiff, maybe just turned 18, do you require the parent to be present? Likewise, if you have an infant, will you do it with just the attorney present, or do you require the parent's participation at that stage? Why or why not? And also, how do you see the role of the insurance adjuster versus the defense attorney? Do you require that the insurance adjuster be either available by phone or physically present?
I'll go first for a change, give my colleagues a chance to think of better answers than mine. Listen, the purpose of a mediation or a settlement conference is to succeed in resolution, or at a minimum, move the ball forward. You cannot do that if you don't have the appropriate parties present. Now, what do I require? I require that the lawyers know that. I don't have at a settlement conference the power to summons witnesses and to force people to be there. The settlement order in Baltimore City says that the party shall have all persons present who are necessary to make the decision. And that varies from case to case. So that's the settlement order scenario. For mediation, now this is a private mediation in which the mediator is being paid handsomely for his or her services. So do I need to call the attorneys on the east side and say, be sure that you have the person there that needs to be able to make the decision? Well, that seems to me to be redundant and almost asinine. I mean, if you're going to come to a mediation and you don't have the persons there to make the decision, then I'm going to send you a bill anyway. Thank you very much. That was a short, that was a short day. But the settlement conference is one thing, the mediation is another. At a mediation, it's, as I said earlier, it's difficult to tell who that decision maker is. And the lawyers know better than I. I can't tell you how many settlement conferences, for example, I've conducted in the courthouse in which the landlord says, just a minute, before I approve the settlement agreement, let me call my spouse who's home. And all kinds of scenarios that can go into that. So, the settlement order in the courthouse has certain requirements. Mediations have just certain common sense portions to it. The question about, in your opinion, what is the insurance adjuster's role versus the defense attorney's role? Well, I got in trouble at a mediation just a couple days ago because I have a habit as the dollars begin to flow back and forth. I kind of bypassed the defense attorney and talked directly to the adjuster. And the attorney said to me, quite frankly, Judge, I'm not a potted plant here. I have some say. And I said, well, you're absolutely right, counsel. I apologize. And I did profusely. The insurance adjuster, in my opinion, is as important. The two most important people in any settlement discussion, the two most important people are the deciders, the plaintiff and the insurance company who is going to fork over the money. I often say to plaintiffs, you have the demand, but they have the money. The attorney, in my opinion, and it depends on the relationship between the attorney and the adjuster. Sometimes that's almost adversarial. Sometimes the adjuster doesn't trust the attorney. Sometimes the attorney doesn't trust the adjuster. Those are the worst case scenarios. Sometimes they've been working together and they think it's one entity. It is important as a settlement officer, and especially a mediator, to figure out what that dynamic is early on. Just like on the plaintiff side, I have to try to figure out who's driving this train. I know the Court of Appeals of Maryland, the highest court, says the client is the decider and they are the ones that make the decision and they're driving the train. Well, that can be true, but many times the client is looking at the lawyer and saying, you think I should, what do you think I should do? Well, that tells me a lot about who I should be focusing on and what I should be doing. one of the problems I think that has evolved over the years, and it is a problem, not a problem, but an issue in lead paint, is that the role of adjuster and lawyer is to figure out what that relationship is. And we have a lot of litigators, we have a lot of attorneys, but I'm not so sure that we have a lot of counselors. So all of you are counselors at law. And I see the role of the attorney versus the adjuster is that of counselor. But that depends on what that dynamic is. And you need a little bit of discussion and some confrontations and some insight to figure out what that role is and act accordingly.
Thank you.
Just a couple comments. Especially with the mediation process, you know, I understand the pretrial conferences, there's an order that requires, you know, all persons, you know, who have the ability to, you know, settle the case to be present, all those with authority. With mediation, where you're talking about a process, it seems to me it's critical, obviously, common sense, as Judge Gordy says, for those folks to be present, because during the course of that process back and forth, what you're hoping is that everybody who's there is going to have somewhat of an open mind to reevaluate positions as the course of time goes on in light of the factors that are being discussed. What are the strengths? What are the weaknesses? What's the jurisdiction? You know, what are the possibilities? In this case, are there some clear, already outstanding, you know, red flags that say this case is one that could find its way to the Court of Special Appeals of Maryland or beyond, and how will that affect, how much longer is that going to take? Perhaps in New York, the appellate courts have gotten speedier. In Maryland, they seem to have slowed down a tad, wouldn't you say? And so, you know, getting a decision 13, 14 months or more, 3 years, is, you know, becoming, you know, not uncommon. So those factors as well. But in order for the process to, whatever dynamic goes on, people have to be there, have to hear, and in person. I mean, I've had cases where say, could my adjuster be present by telephone? Well, you know, early on I'd say, oh, sure, because I'm such a nice person. Now I say no. I just, you know, if the date's not good, let's find another date. Let's find a different location. But everybody needs to be there, in my view.
Can I add one point?
Certainly.
Sure, Judge.
Well, as far as who is going to be at the conference, maybe needs to be broken down a little bit as to who's going to be there for what part of the conference. And at least in lead paint cases, you know, everyone there is sophisticated with knowledge of this litigation. The adjuster, who's been doing it forever, the defense lawyer, and plaintiff's counsel, and the judges. The only person there that's not sophisticated, or persons, are the client and their parent. And they're hearing all kinds of fancy terms walking around, being batted about, and all kinds of huge numbers that many of them have never dreamed of seeing or hearing in their lives. And I think it does the plaintiffs a disservice to have them present at all stages of a settlement conference or a mediation, because they may become delusioned or disillusioned or get a misimpression when they hear a number. Let's say a case is worth X number of dollars in our view, in the plaintiff's counsel's view. We say it's worth, and we've evaluated and discussed with our clients, and we think it's worth $500,000, $600,000. But then the defense adjuster or lawyer bats around the number 150, 200. It's very hard as a plaintiff's lawyer to, at a settlement conference, when you hear that kind of number, to engage in further negotiation. So I think instead of who should be there, it should be who should be at what part of the conference. And they should always be available outside or in a different room so you can negotiate and convey offers as we're obligated to do, but not always present right when the talking is going on.
This is point counterpoint. Brian, you ignorant? No. He knows I'm only serious. I think that raises a point about what you need to do to prepare your client for the process. And I know that you do a very good job preparing your clients for the process, because I know that you will tell them, look, you're going to hear some things that are said today that are going to be upsetting to you. You're going to hear some things that are being discussed about you, your family, about, your family's, success in school, your intelligence, and you're also going to hear some numbers mentioned and laid out there. So I think that I appreciate it's a point of sensitivity, but I think that you can do, and that's your obligation as an attorney, to prepare your client for what is going to come. I'll also say that, in the course of a mediation, I think, and Judge Gordy and I, again, have talked about this lots of times, you change gears and you do what you think might be helpful at the moment. There are lots of points of discussion. There's some of those points of sensitivity about genetics, about, whether the mother is, was using crack when the child was in utero, is still using crack, all those kinds of things. Sometimes those are things that I might be more likely to discuss with, kind of pull the attorneys out and say, can we just need to chat with you in the hallway for a minute? Can we talk about this? And there are times when I've been told, yeah, thank you, Judge. I don't really want to highlight all of that. It's hard. This is hard enough for my clients, to hear. So, I think there are ways around that, but I think that the folks still have to be there, and maybe that's, preparation and, adjusting as time goes on, to the realities makes it workable. Oh, Lord.
Whatever works for you is fine, but I have some real ethical concerns about that process as a mediator, especially as a retired judge mediator. It seems to me that it sets up a scenario like this. During the debate with your client absent or not hearing about the offers, an offer is made for $400,000. You turn it down because you think the case has a whole lot more value. The mediation fails. The case goes to trial. There is a verdict for $100,000. Whatever works for you, fine. But that I have had scenarios where the plaintiff's lawyer has told me, Judge, I won't communicate an offer to my client until it reaches a certain level.
If I could
Yeah,
just
Judge
chime in
Rosenbaum
for
needs
just
to
a
get
second.
in here.
New York's here. Hi. In the house. Anyway. For New York, I will tell you that I require at a settlement conference that the parties either be present or available. That's phase one. I also remind the attorneys that for very serious ethical purposes, they have to convey every single offer to their client. They generally come to me and tell me, I developed a rapport with both sides, and they'll say to me, Judge, this is where I'm at, and this is where I want to start. That makes it a lot easier for me and also for them, because I know they don't have to keep calling their clients till they get to a point. Now, I have to say, I do agree with both the lawyers. It gets very confusing for the plaintiffs, but I want to make sure they're available, and I always ask the attorneys if they're available for their benefit, not for my benefit, but for their benefit. Relative to the carrier, it has happened on more than one occasion that all of a sudden the carrier is unavailable. And I've asked the defense attorney to please call the carrier, and the carrier has not been responsive. They can't locate him, and it's become a waste of time. And it's a waste of time for, I feel, both parties, because it's not fair, it's not right. In New York, we do have an extra hammer as judges, and that is if they are not available when they were supposed to be available, the next time they have to come in. If they don't come in, the judge has the authority to sanction them. I guarantee you, they come in or they're available every single time because now I have that hammer. Now, I have that hammer, and I have it, I'm in New York State, keep that in mind. But that has been very effective. So when it comes to the settlement conference, again, having known the attorneys, gotten to know them since I've had them since the inception of the case, and they know where I'm coming from, I don't require the parties to be available. I require the attorneys to be present before me. No phone conference on a settlement conference. But in terms of the other parties, they're not required, but if I see a breakdown, they get brought in right away.
Thank you, Judge. Thank you, judges. Last question before we'll certainly open it up. I think you may have all touched on this in one way or another, but certainly for any settlement conference or mediation to be successful, the attorneys, the adjuster, the plaintiff, hopefully is at a point where they have realistically, that's the big word, realistically evaluated their case. Hopefully as attorneys at that point in time, we know the facts of our case, but oftentimes we need the court or the mediator to bring, objectivity and maybe a more thorough analysis without the emotional response. I think this year it's been a little more low-key than other years, but I think it's safe to say that this is a very, while we all get along great, I think we all bring a lot of, emotion to what we do, and I think that's what makes us good lawyers. But in any event, we do bring that into the courtroom, we bring that to the mediation session, and we bring that to a settlement conference, even if we shouldn't. There are some cases that get to us more than others. How do each of you help, really the attorneys, have a realistic, be in a position to realistically evaluate their cases?
You mean take the emotion out of it?
Yeah, help us take the emotion out of it.
Again, you develop these relationships. I mean, if I have a new attorney before me, and they're getting emotional, and there are attorneys in this very room who have gotten very emotional about their cases, and I appreciate that. I came from private practice, and I know that I got emotional about my cases. That's, again, the human element that judges find fascinating, and not just from an observational standpoint. We are told we are supposed to watch out for human frailty, and not just, and it can extend beyond the clients of the attorneys. It extends to the attorneys, but then they have to be reminded of what their charge is and what their duty is as attorneys. It can be easy as a reset on just saying, "Come on," and then they step back and they realize it. But there are other times where it is. And it can be dangerous. It becomes the principle of the matter. And we've all had clients where, for them, it's the principle of the thing. And those generally don't end well. And so, sometimes I will describe to the attorneys of, now we're going to have a therapy session, and we're going to discuss this. We're all human beings, and that includes the judges. And we all make mistakes, but you shouldn't be insensitive as a judge to the way another person feels about their case, but you should try to help them to direct to what they're going to do that's in the best interest of their client.
Thank you, Judge. Judge Gordy?
It is essential to be a good mediator, I think, is that you have to first be a good listener, because it is important what people say and how they say it, what they don't say, body language, etc. All that is a listening skill. After you've listened, you can then respond better. Many times a lawyer's argument or presentation will go in the line of, if my client testifies like they did at deposition, and if my expert witnesses testifies like he has in his report, and if I get the right jury, blah, 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 I have to hold my water and not respond with, if a buzzard had a harp on his back, there'd be music in the air. So after you have listened, I think then you can start to deal with the pluses and minuses. Lawyers are trained and taught to posture well. But there comes a time, if you have been around the block a few times and tried a few cases and listened to some woeful wailing and crying after the verdict has been brought back from either the plaintiff or the defendant, after the posturing is done, you begin to talk about reality. And the reality is usually around either overvaluing or undervaluing your case. And there are two kinds of essential mediators, or probably hundreds of subcategories, but the two categories are those that are evaluative mediators, who look at the totality of the circumstances and try to move the parties toward their number during the course of the mediation. Then there are those mediators more like Judge Smith and I, who are more facilitative mediators, who try during the course of the discussion to move the parties toward what they believe is their number. And that is only done with reality checks and considering the pluses, the minuses, and the exposures. And my final comment is that who do I like to see at mediations on the plaintiff side? The adjusters and the defense counsel are always, one group. But on the plaintiff side, who I really like to see are a good lawyer and a grandmother, because young mothers are influenced by the fiance's desire for the new Cadillac and other things. But I love grandmothers, because grandmothers have lived long enough to follow that old adage most of the time that a bird in the hand is worth two in the bush.
I don't think I can beat the buzzard comment. But let me just say, I've never heard anything like that in my life. But
You're not a farm girl.
It's true, I'm not a farm girl. I'm a Baltimore City girl. I think of myself in some sense as being an interested, active listener, trying to respond, trying to have digested, in a few hours what it's taken the lawyers, months and months and months to learn about. And I'm trying to, work with the parties. I'm also, I think, my job is to get however many parties there are into a range, into a bargaining range, because let's be honest, when we start off most mediations, they're nowhere in the range of where the case is going to settle. In terms of, and it sometimes is necessary to, even starting off. The worst scenario of all is to have, plaintiff make a demand that is in excess of, the home run kind of value of a case, every dollar that could be put on a blackboard in front of a jury. And when that happens, I discourage that and say, if you do that, first of all, what's the basis for really that interesting, opening demand? And if you do that, you're going to get a response that is going to be very frustrating and upsetting, and it's going to send a message back to you about what the folks think. So, and I think that I can say that, Judge Gordy described his approach and mine as being facilitative. Is that what we're doing? Facilitative. And I think that's true, but as you get down to the wire, I think that he would acknowledge that he can be a little more evaluative as you really get near to it. And I acknowledge and admit, is this being recorded? That so can I. But I think it's really, I expect that the lawyers and the adjusters, who are in the business have made a realistic assessment and know, at least from their perspectives, what the values are and whether we're going to get there. As a last-ditch effort, I think it's my place to say, this is what the dollar value of your case is. So, thank you.
Thank you.
We have a question from Steve.
Judge Smith, to follow up on that, when do you make the recommendation and when don't you? 3 days ago in New York, I participated on a one-on-one mediation that failed, and the mediator told me repeatedly that my numbers and my indication of where I could go with my numbers were in the ballpark, and that the other side, my adversary, was unrealistic. And I said to him over and over again, listen, you need to make a recommendation so that you can start batting us both over the head. It never happened. So, when do you make it? I mean, I understand a sitting judge, might not be able to make a recommendation if the case is going to a trial like that. But as a mediator, when do you make that recommendation and when don't you?
I probably don't do it very early on when I do it, because I think I want to get some sense about, Look, for the first 2 or 3 rounds of going back and forth, I'm trying to read between the lines and figure out really what people's strategies are and what their plans are and where they're trying to get to. And frankly, if I don't have to give my sense about what the number is, I think that's the ideal scenario. But, you know, when there are cases where, you know, if somebody asks me too early on, I'll say, you know, I'll give you a number later, but I think we need to work this out. I think you need to be reevaluating your position before we get there to my number. I have, I guess, in at least, you know, one case at the suggestion of one of the attorneys said, look, Judge, we're just having a really hard time here, and, you know, we can't seem to get in the range, whatever. How about if, you know, you write down your number for the case and then, you know, give it to each side and look at it, and if they take, then fine. I've done, you know, that sometimes works, you know, just sort of, here's my secret number, you look at it secretly, you look at it, if you can agree, yes, right, yes, then we'll keep, if you say, somebody says no, we keep talking. You know, or I have sometimes asked lawyers to, you know, to the folks to, okay, you write down your number, I'll be the only one who knows what your numbers are. If they're on the money, which sometimes, you know, in the olden days, that's what lawyers did. You know, you'd sit across from somebody and say, look, here's my number, you know, and yeah, surprise, that's my number too. That doesn't seem to happen as much. But if, you know, if they're both in agreement, fine. And if there's one no, then we keep talking. Continue it. So, if I'm going to give you my number, it's going to be probably a while on in the process. You know, and there are mediators, there are, and I think, honestly, they're all retired judges, who are known for really, you know, you're saying beat us, you know, the kind of beat us into submission. You know, my experience is that you always want me to beat up on the other side. You don't really want me to beat up on you, so it's kind of a delicate situation. I'm not likely to, you know, be brutal, but I am likely to keep asking questions about what you perceive as the strength of your case.
Thank you, judges, very much. Did you want to add something else, Judge? Okay, we'll see them again for the judicial roundtable. Thank you.